Welcome to this orientation on antitrust and the real estate profession. We'll begin with a brief overview of antitrust law, and then we'll bring the law to life by taking a look at some examples of real estate agents in situations in which antitrust violations could occur. Why is antitrust a major concern for real estate professionals? Real estate brokers vigorously compete to secure an inventory of listings to offer for sale. But brokers also regularly cooperate with one another to sell those listed properties. This dual tradition of competition and cooperation presents frequent opportunities for antitrust misconduct, as we will see. The foundation for federal antitrust law is the Sherman Antitrust Act. The Sherman Act establishes two basic elements of an antitrust violation: an agreement, understanding, or conspiracy among competitors that unreasonably restrains competition. Penalties for antitrust violations include liability for 3 times the plaintiff's actual damages, payment of the plaintiff's reasonable attorney fees and costs, court supervision of the defendant's business for as long as 10 years, and prison terms. As a real estate professional, it's important for you to be aware of how your words and actions can inadvertently move you into dangerous antitrust territory. And of course, it is vital that you know how to properly handle these types of situations. Let's take a look at Phil and Kelly, 2 agents who work for the same firm. Kelly is an experienced, very successful agent. Her broker has come to appreciate her knack for mentoring less experienced agents like Phil. Phil is ambitious and hardworking, but he has only had his real estate license for a few months and is seeking just his second listing. Phil has a listing presentation today. As you watch how he interacts with the sellers, see if you can identify any behaviors that may be potential antitrust violations.
Have some more cake. So I keep telling Wayne, well, why don't we just put it on the market already?
And I keep telling her we will, but not unless we shop around a little. Now, it's like I always say, I don't care who it is. A real estate agent, an oral surgeon, or a roofer. You've got to get 3
bids.
That's right. Now, we need to feel that we can work together, right?
Oh, absolutely, Mr. Grady.
Wayne.
Oh, and I'm Sarah.
Sarah. Okay, so what do you think?
Well, no. What's this commission, 5%?
Well, that's the part of the sales price that goes towards my...
We know what it is, but isn't that high? I mean, Sarah, didn't the Browns pay...
4%.
Yeah, 4%. Mm-hmm. So why is yours more?
Well, it's compensation for my services. Marketing the house, running the ads, conducting all the showings, open houses.
Couldn't you do that for 4%?
Not really. Actually, commission rates are pretty standard.
Well, then, why did our friends pay less?
Well, there are some firms out there that try to get away with it, but most of the responsible firms in the association go along with the program.
Oh, yeah? Well, we just talked to a woman from, Sarah, what was the name of that place?
Rock Bottom Realty?
Right, Rock Bottom. And she said she would put our house in the MLS for $500. $500. We can still sell it ourselves without paying a dime more, and if an agent from another firm brings in a buyer, we only have to pay a 2% commission. Now, that's less than half of your commission.
Rock Bottom. Well, you're right. They do charge only $500 to list your house and put it in the MLS, and you would pay just a 2% commission if an agent from another firm delivers the buyer. But that's the problem. See, for that amount, no other agents want to show Rock Bottom's listings because they have to do all the work that Rock Bottom should be doing. So it actually costs you more in the long run because it takes you longer to sell. See, if I lowered my commission rate, I'd also have to lower what I offer other agents in the MLS, and no one would want to show your house either. So really, it's in your best interest for us to charge the standard commission. See? You follow? Most of us think Rock Bottom's listings shouldn't even be in the MLS. this cake.
If you were in Phil's position, being questioned about your commission rate, would you have handled the situation differently? After his presentation, Phil meets Kelly at a coffee shop, and she asks about the meeting. Let's see if your ideas about what Phil might have done wrong are the same as those offered by Kelly.
I'm starting to wonder if I'm even going to get another listing.
Oh, it couldn't have gone that badly.
No listing.
Well, you said they were still shopping around.
They didn't want to pay our commission, bottom line. And that was even after I told them it was the same thing everybody else charges.
You didn't say that.
Why?
Phil, what you said makes it sound like we all got together and agreed on a fee. That's what antitrust lawyers call price fixing. You don't remember that from orientation? Do you remember that you can go to jail for price fixing?
Come on, Kelly.
No, really. I know you didn't mean that, but just the same, that kind of talk could get you in a lot of trouble. It gives the impression that all the firms around here agree on the fees they charge. If the jury gets that impression, it doesn't matter what you meant. We're all guilty.
Oh, you make it sound like I'm headed for a guest spot on America's Most Wanted. Come on, it was just a little remark, that's all.
I know it was just a remark.
I really wanted to get that listing. Besides, as far as I know, our commission is the same as most other firms in town.
But it doesn't matter if most firms charge the same if they haven't agreed to do it. But you made it sound like that's exactly what's happening, which is price fixing. You shouldn't use words that even imply we've colluded with other firms.
Aren't you overreacting?
Well,
It just bothered me that they were so impressed that Rock Bottom Realty could charge $500 just to stick the house in the MLS and not do anything else. I just wanted them to know that no one would show their house if they listed with Rock Bottom.
great, Phil. Now you're 2 for 2.
What? Oh, I know. I'm guilty of bad-mouthing another firm, right?
Try boycotting another firm. You know, I don't want to kick you when you're down, but what you said makes it sound like all the other firms in town are working together to drive Rock Bottom out of business. You need to know what you can say and what you can't.
It's not what I meant.
I know that, but the sellers don't, and what you implied could cause real problems. Even with, say, advertising, for example. We can do whatever we want, right? Run our ads in any paper, pull them if we think that the rates are too high or the print is too small, but do that together with other firms, and it's a group boycott, an illegal boycott. Boycotts, along with price fixing, are the most common antitrust allegations that people in our business face.
I should have talked to you before I went.
If someone questions you about your commission, you come back with a clear description of all the services you provide. Tell them why you're worth it. Stress our company's track record. Focus on making the sale quickly at the listed price. Show them how your marketing is going to accomplish their goals.
As Kelly pointed out to Phil, the two antitrust violations that are of most concern to real estate professionals are price fixing and group boycotts. Both of these are per se restraints of trade, meaning that the plaintiff does not need to introduce any evidence that the restraint had an actual impact on the market, and the defendant is not offered a chance to justify his actions as reasonable. As a real estate professional, you deal with customers and clients, competitors, and other service providers. It is important that you know how to limit your risk of antitrust liability in your relations with each of these groups. One of the fundamental decisions that any business must make is establishing the price it will charge for its products or services. Real estate brokerage firms are no different. Each firm must establish the fee it charges for its professional services. The keys to avoiding antitrust violations or claims of violations alleging illegal fee setting are to establish fees without consultation or discussion with persons affiliated with any competing firm, to be sure that all brokers and agents in the firm understand that the fees charged by the firm are not and may not be established by agreement with other firms, and to ensure that when the company's brokers or salespeople discuss fees with clients, they use words that clearly indicate that the company prices its services independently, and that there is no unintentional inference that fees are set by agreement with other firms. This means never responding to a question about fees by referring to pricing policies of other firms. You should respond to questions about your commission by pointing out the value of the services the client receives for the fee charged, and how your services are most likely to lead to a transaction at a fair price in the shortest period of time. It's also important to understand that it is unlawful to agree with other firms about non-price aspects of the terms on which a firm provides its services to clients. Firms may not, for example, agree with other firms about the terms of their listing agreements, including the length of a listing, the type of listing agreement, or the formula upon which compensation will be based. Illegal price-fixing conspiracies may involve not only the fee a firm charges for its services, but may also involve the cooperative commission split, that is, the fee paid to the successful cooperating broker who delivers a ready, willing, and able buyer for a listed property. It is illegal for brokers to agree or conspire to fix the amount of the cooperative compensation paid to other competitors. Listing and cooperating brokers may, of course, discuss or negotiate the compensation they will pay to each other. However, these discussions should never include representatives of a third firm or address what each broker will offer to pay to other firms. In addition to price fixing, a group boycott is a violation of the antitrust laws. A group boycott occurs where two or more competitors agree not to do business with another firm, or to do business with the other firm on agreed-upon terms. For example, a broker may decide to offer one or more potential cooperating firms a different commission split than it offers to other cooperating offices. This is permitted by antitrust laws, so long as it is done without agreement with other firms. However, if a number of other firms simultaneously determine to offer a similarly lower split to a given firm, that may imply a conspiracy against the firm offered that lower split. Therefore, any decision to vary the firm's compensation offers should be carefully considered and, if made, documented in order to be able to rebut any inference of conspiracy with other firms who may also be offering less compensation to that firm. In the same way, you should never suggest to a potential client that they should not do business with another firm because other brokers will not cooperate with that firm. A statement like that suggests that everyone understands or has agreed to refuse to do business with that other firm. After Phil and Kelly met at the coffee shop, Kelly headed to a listing presentation of her own. Let's see how she handles questions about her commission.
So it sounds like you think it'll really sell, huh?
We just don't want it to sit around for 18 months like the place across the way.
I understand, but your home has some very desirable features. End unit with a balcony, panoramic view, hardwood floors throughout, granite countertops, a high-tech security system.
And the price?
Based on the comparables, Donald, I feel very confident that we've priced it right.
I guess we ought to make it official.
Whoa, whoa, whoa. I know you told us already, but could you explain the part about the commission one more time?
Oh, sure, Allison. It's 5% of the sales price.
And that's standard, right?
I don't think your brother's broker got that much.
There's no such thing as a standard fee. Our firm determines its commission based on the services we provide to make sure you meet your real estate goals.
You mean a quick sale at a good price?
Right. You need to sell quickly because of your transfer to Cincinnati. And we've agreed on a price that reflects fair market value. Now, to make sure we meet these goals, I'll do several things.
Like advertise the place? Have an open house?
Sure, but I'll also do a lot more than that. I'll put together a comprehensive marketing plan and put your home in the multiple listing service, which will make it available to all MLS participants. We'll run regular newspaper ads and advertise it on Realtor.com. We'll coordinate or arrange all the showings. Buyers will be screened to weed out the serious from the curious. And because our firm is associated with a relocation plan, we'll have an even larger pool of serious buyers.
Well, that's gotta help.
And when you do get offers, we'll help you evaluate each one, whether to accept it or reject it or make a counteroffer.
And we hope to be making those kind of decisions real soon.
Well, as I mentioned before, our firm sells homes that we list in significantly less time than average for our market. But of course, all the things we do to sell your home cost money, and you don't pay the commission unless and until there's a sale that you are satisfied with. I think you'll find the quality is worth the investment, and the returns you get will more than justify the commission we'll earn.
Honey, I'm sold.
All right, let me sign this thing.
Right there.
By their very nature, realtor associations consist of a group of competitors who may violate the antitrust laws by agreeing among each other in the ways just described. That is why it is important that brokers who participate in the affairs of an association of realtors be alert to discussions at association meetings relating to commission levels, pricing structures, or marketing practices of other brokers. Brokers who find themselves in the midst of such discussions should immediately suggest that the topic be changed, and if unsuccessful, should promptly leave the meeting. If minutes of the meeting are being taken, the broker should insist that his or her departure be noted for the record. Competitors are not the only potential targets of a group boycott. Another type of illegal group boycott is one targeted at a supplier or purchaser. A familiar example of a temptation for brokers to engage in a group boycott of a supplier occurs when brokers become frustrated with a local newspaper's advertising rates or editorial practices. Any agreement to reduce or stop advertising in the paper would constitute an illegal group boycott. Agreements among brokers to act collectively with respect to other suppliers, such as printers, sign makers, or hardware or software vendors, are likewise vulnerable to antitrust claims. Real estate brokers' compliance with the antitrust laws is directly related to their ability and willingness to educate their salespeople. The broker should ensure that the salespeople have at least a working knowledge of how antitrust laws are applied in the real estate industry. Every real estate brokerage firm should have a written, office-wide antitrust compliance policy that is applicable to every employee and independent contractor. A salesperson should report to his or her broker or sales manager any suggestion by salespeople from other firms that could be interpreted as an invitation to fix commissions or boycott a competitor. Once an incident has been reported, the broker should immediately take steps to disavow any participation by the firm in such a scheme. When we saw Phil earlier in the program, he had put himself in a precarious position because of his lack of awareness of antitrust red flags. Let's look back in on him a few weeks later to see if he's learned his lessons.
Have you seen this new listing? Look at this.
Phil Walker. Jeff. Hey, sure. How's it going? Good. Pretty good. Pretty busy. How about your firm? Good. Yeah, I read yesterday's Gazette. Oh, yeah. The ad for the Internet Realty Associates? I saw that too. What do you mean a bunch of us are getting together to do something about them? Well, of course I'm concerned about a new competitor. And I know a little bit about these guys, and I know they're pretty smart. But that's not the point. Jeff, we'll figure out for ourselves how we can best compete with other firms. I don't care what other firms... No, I don't even want to know what firms you've been talking to. Or what you might be talking about doing. Look, you're asking for trouble. I've already heard more than I want to. Yeah. Goodbye, Jeff. Can you believe that guy?
I wonder if he even knew he was doing anything wrong.
How could he not know? Okay.
Look at this. Incredible.
In their day-to-day business decisions concerning the fees they charge clients, commission splits paid to cooperating offices, or other business practices, real estate brokers must be certain that their decisions are the result of independent business judgments about market conditions facing the firm. Consultations with competitors about these decisions can result in otherwise reasonable actions being held to be illegal. Finally, antitrust compliance is not simply a means to avoid liability and litigation. Universal antitrust compliance ensures the ability of all competitors to succeed to the extent their skill, industry, and foresight will permit.